in the matter of the marriage of Kendra Lee Pirtle and Jason David Pirtle.
Kendra Lindsay, formerly known as Kendra Pirtle, appears along with attorney Shannon Cooper.
Jason Pirtle, the respondent, appears by and through Susie Locke. Also present in my office is Julie Pirtle, who is Mr. Pirtle's new spouse.
All right, very well. This matter comes before the court at this time for further proceedings in regarding to a motion to modify the permanent parenting plan that was filed earlier.
All right, buckle up, everyone, because this case dives straight into one of the most heated issues family courts ever deal with: education, parental rights, and a massive relocation that completely upends the kid's schooling routine. Today we're looking at the marriage and now the legal battle of Kendra and Jason Pearl. Mum moved an hour and a half away. The kid's schooling has fallen into chaos, and the 9-year-old shockingly tests at a kindergarten level. And the court, they're about to decide whether homeschooling continues or comes to an abrupt end. Trust me, all want to pay attention to every twist in this one.
By Jason in the case. What is the current status of this, Ms. Locke?
Your Honor, the issues remain largely unresolved. Miss Pirtle relocated to Cheney. She was homeschooling the children. Just for a little frame of reference, I guess, the parties used to live about a mile apart from each other. So when they got divorced, Mom was able to continue to homeschool the children. Dad brought the children to her on school days during his parenting time. And they went to school, and then they went back to his house just like they would a normal school setting. Obviously, when Mom moved to Cheney, that became completely disrupted. The parties are still doing a 4 days on, 4 days off schedule for parenting time. And right now, the children are bringing their schoolwork to Dad's house if he has them on school days. And my client's new spouse, Miss Pirtle, is doing the homeschool work at her home during the parenting time. Otherwise, the issues in our motion have been unresolved.
What are the other issues in your motion?
We asked for the children to move to an online schooling system so that there was some consistency in school, so that the parties would be on the same curriculum and there wouldn't have to be this travel back and forth of the school work. Since filing the motion, the kids went through some testing to determine what grade level they are at.
This moment right here is where the judge's concern spikes, and honestly, can you blame them? The youngest child, at 9 years old, testing at a kindergarten level is a major red flag in ANY educational setup. And notice, Dad's attorney immediately seizes on this as justification for switching to an accredited online school. The big question becomes, how much responsibility falls on the homeschooling parent when such a dramatic gap appears? And what should the court prioritize? Parental preference or the measurable academic needs of the child? Let me know what you think. Should homeschooling continue, or is it time for a structured system with real benchmarks?
The youngest child, who is 9, tested at a kindergarten level. And so obviously that's pretty concerning. So we would like to move to a standardized school system in an online Christian school system, and hopefully get the kids back on track.
All right. Are there other issues besides that?
Transportation, but the parties have kind of tentatively been working through a plan on transportation.
All right. Ms. Cooper, and I'm not sure why Kendra's not fully on the meeting with us, but she appears to be on with perhaps audio, but not video.
Okay.
Ms. Cooper, why did your client move to Cheney?
Your Honor, she and her husband relocated fairly recently. They had an opportunity for better housing. They think it's better for the entire family. It's closer to extended family on her side. She wants to continue homeschooling the children. It's been consistent with her She has reservations about the proposal made by respondent and Ms. Locke as far as the program that they're suggesting. She doesn't think it's best for either of the kids who are involved in the homeschooling. She knows that there are issues as far as testing at this point, but she's been working with him. She feels like she's in the best position to continue to be the provider of the schooling. As Ms. Locke stated, we haven't really resolved any of these issues. She and I have talked somewhat about it. My client's proposal would be continue homeschooling with her. Potentially the scheduling would need to change to where the kids are over at respondent's home less often, but perhaps it could be more consistent with what the days that he's actually off from work. On the 4 days when he's not having to have the obligation to be at work, he can actually be there for the kids. So that's more along the lines of what she thinks is in the kids' best interest, and mainly consistency with the schooling, instead of having to change to some new program as respondent has suggested. She thinks that they can continue to make the progress in the program that she's already conducting with them.
Except one of the children clearly is not making progress with the current educational program. Would you agree?
Well, she understands that he has issues, but she's in the best position to help him through those.
Here's where things get even more complicated. Because Mom moved an hour and a half away, the children now spend huge chunks of their schedule just driving back and forth every 4 days. That's not a small commute. That's a full-on disruption to routine, schoolwork, sleep, and daily stability. And remember, these kids are already struggling academically. Judges take relocation very seriously, especially when the move clearly affects the other parent's ability to maintain consistent schooling. So the question becomes, did this relocation serve the kids' best interests? Or did it create a ripple effect that's now hurting their education? If you were the judge, how would you weigh the relocation factor?
Did I hear right that a 9-year-old is performing at a kindergarten level?
Yes, Your Honor.
Just the court's initial reaction would just be, it sounds like she's already had time to bring this child up to an appropriate grade standard in comparison to age and hasn't been able to do that. What's going to change so dramatically that he's going to get caught up?
Well, and Your Honor, we may need to explore some other alternatives or maybe alternative testing. I don't know the details on the testing that Ms. Locke is referring to. I think there may be some more there. He may not be quite as behind as is indicated by Ms. Locke. So, and like I said, she can work with him. She's worked with other kids in the family in the past, gotten them through school.
Okay. So I suppose this begs the question, where do we go from here, Ms. Locke?
Right.
Your Honor, I think we're going to have a hearing. I'm ready to argue today about why we should modify to the online school system. But if Ms. Cooper's client's position is that my client should have less parenting time so that she can continue to school the children, obviously we would have a major objection to that. And no response has been filed to our motion. So we don't precisely know what Ms. Lindsay's position is. Additionally, Your Honor, since the move, it's been about a month. It is a lot of drive time for these kids. So that is something that me and Ms. Cooper definitely need to discuss. Every 4 days, they are traveling back and forth from Cheney to Atlanta, Kansas. So it's a pretty significant amount of time that they're spending on the road.
That apparently is a reality of the current situation, though.
That because Miss Purtle moved away or Miss Lindsay moved away. That's accurate.
All right, Ms. Cooper, do you see things differently? I will need you to unmute yourself, though, if you're going to talk to us.
I'm sorry. As Ms. Locke indicated, I agree that the parties have been attempting to work with each other and getting through this transportation issue. I hope that they can continue to do that and make things work. I think that my client continuing with the school is still appropriate. And again, I think we can probably modify the schedule to where, I'm not necessarily saying dad would have to have or should have less parenting time, but I think what I'm talking about is quality parenting time. Essentially, while mom was living closer to dad's house, kids were spending a significant amount of time at mom's because of the homeschooling during dad's parenting time. So, I mean, it wouldn't really change all that much if we modified it to where they're with dad when he's off because he's actually around as opposed to not around.
Hmm.
But I don't know that we, I don't know if that's something we can all agree to, but I think it's worth exploring. I think we may have to schedule a hearing if we can't resolve these issues.
Your Honor, just for clarification, my client's parenting time is on his 4 days off from the refinery. So he already has, the schedule is already that he has the children when he is not working at the refinery. It's 4 days on, 4 days off. The change is on school days, they no longer go to school, which happened to be at mom's house. That the schooling is happening in my client's home because Miss Lindsay moved an hour and a half away rather than 2 minutes.
And I guess I wasn't explaining it very well, but I mean, what I'm saying is that essentially was, while it was on dad's time, the kids were spending the majority of their time at mom's because of the schooling.
All right. Ms. Locke, if the stepmother has stepped in to take over with the homeschooling and that appears to be working, why does there need to be any other changes?
Your Honor, we want the kids to go to a curriculum that has some sort of obligations, some requirements, some benchmarks that the kids are meeting, some testing requirements. It's an accredited school. It would allow consistency in both homes for schooling, as well as expectations in both homes for schooling. There's clearly some deficiencies in the schooling so far. And I think both homes hope that those gaps can be closed, but they need to be closed soon while the kids are still in elementary school.
All right. I'll address my assistant. Mandy, what hearing times do we have available in January? I
In
think
January?
December's not going to be realistic.
Okay. We have January 13th open.
Okay, let's just inquire about that first.
Your Honor, that is the day the parties have a special needs child. She's 16. She's having a pretty significant operation on the 13th.
All right, we'll avoid that date then.
Okay, what about the 12th at 11 a.m.?
She may have reached.
And how long is that set for?
Just 1 hour.
Oh, no, we need it.
We need a trial date?
setting. I don't know how much time it's going to take to do this. It may a half day anyway.
Okay, the 16th is open as well.
I'll still be in the hospital. I
Okay,
will still be in the hospital with my daughter.
Okay. We're gonna have to go to February, Judge.
okay.
February 9th, 10th are open.
I'm available both days, so
I am too.
Shannon.
Then February 9, what day of the week is that, Mandy?
The 9th is a Monday, Tuesday is the 10th.
Monday, February 9, starting at 9 o'clock a.m. February 9 at 9 is established as the hearing date regarding any issues that need to be resolved in the case. I trust that the parties can work on an appropriate educational plan between now and then, the way they have here recently.
Will that be in person, Your Honor?
It will be. Courtroom B, Butler County Judicial Center, El Dorado, Kansas. Would like to see exhibit notebooks delivered in advance, if possible. Especially so that the other party can be aware of what's being presented. I think the issues are relatively narrow here, but obviously this court will want to know more about the academy that's being suggested as a possible educational alternative. And I'm sure that there's some sort of documents that they generate explaining about their school, its philosophies, their program, how it works. All right, with that date now established for hearing in the case, Ms. Locke, what else needs to be addressed at this time, if anything?
Your Honor, I would just suggest that Ms. Cooper and I exchange exhibits on February 3rd. That's the Tuesday before the trial.
I find that to be reasonable. Any objection, Ms. Cooper?
No, Your Honor.
Court will so order.
Um,
I guess we try to keep the.
I don't believe we have anything in addition, Your Honor. We would just ask that the parenting plan remain the same unless the parties agree to a modification before the trial.
You agreeable with that pronouncement, Ms. Cooper?
I think so, and I think both parents are probably gonna need to be flexible given the circumstances. And I think so far they have been, so I anticipate they can reach agreements on how to modify going forward, at least for the time being.
Very well then. Ms. Cooper, is there anything else from your side that we need to still address?
And there you have it. This case is officially headed to a full hearing in February, with both parents ordered to exchange exhibits beforehand. The core issue remains crystal clear: whether the children should stay in the current homeschooling arrangement or transition to a structured, accredited online school system. On one side, Mum insists she can correct the academic gaps. On the other, Dad argues the deficiencies and the relocation prove the need for standardized education. Ultimately, the judge will have to weigh academic performance, parental responsibilities, and the children's best interests. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
No, Your Honor.
All right. So a hearing will be conducted, Courtroom B, Butler County Judicial Center in El Dorado, February 9, starting at 9 o'clock a.m. with counsel to exchange exhibits by no later than close of business on February 3. With those rulings made, if there's nothing further, the Pirtle matter will be in recess at this time, and this meeting may be ended for all.